It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. Now that I got your attention, I guess I should probably mention I got a new album available now on my site. Nigga, fuck all that whining and bitching. You looking for greatness, then I'm the description. Dropping me by like a prison. Twisting your brow like ignition and split, nigga. That's what I call on the vision. I'm finna infiltrate, you cannot imitate. I'm from a pedigree, this is not Triple H. I took a road, you can travel like Triple A. Do the impossible, just like a triple play. Genuine energy, I am not Timberlake. But a nigga too insane. Truck for the money, but to pull up in the ring. So I can give a what the fuck about what a nigga think. I'm on some new shit. Elevated my rubric. I'm an industry nuisance, giving my 2 cents. Telling niggas what the truth is. It ain't even about music. Everybody wanna know the G code. Bitch, I got bops on reload. I was just on live 2 hours straight. Ain't playing not one repeat song. I'm ready for the spotlight. I was on the block like a stoplight. Every day I catch lightning in the bottle. The niggas told lies, but not hitting spots twice. Couple years I was living on fried rice. Like a tree when I got to eat Popeyes. Gotta beat them, get your whole top 5. Spit heat on top like a rabbi. It's no. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this Saturday afternoon. Just wanted to come give y'all a quick update that may have been overlooked. I can't say for certain. I haven't been watching a whole lot of videos this past few days or whatever. But y'all know we've been keeping close tabs on this Megan Thee Stallion and Milagro case out in Florida. And the judge on Wednesday, before end of day came, put the instructions out there for the jury to adhere to. All right. Now, as we know, the verdict has not been reached. Wednesday was their last day in court. They will go back on Monday morning. So still got a couple days before we find out what exactly the verdict is going to be, what they deliberate about, and how they view this case in totality. But I do want to read the paperwork from the judge to the jury so that we can understand what exactly they're going to be deliberating on. We've already read the questions, right? So we don't need the questions that the jury has to answer. But this is the actual order from the judge on how to evaluate things in this process. All right. So I'm going to go ahead and pull this up. We're not going to be here for a very long time, but just for the sake of transparency and knowing that everybody has probably not seen this paperwork, I wanted to just go ahead and present it. And again, we'll find out on Monday what their evaluation ends up being. So this is an 11-page filing. It says court's instructions to the jury. Members of the jury, it is my duty to instruct you on the rules of law that you must use in deciding this case. When I have finished, you will go to the jury room and begin your discussion, sometimes called deliberations. Your decision must be based only on the evidence presented here. You must not be influenced in any way by either sympathy for or prejudice against anyone. You must follow the law as I explain it, even if you do not agree with the law, and you must follow all of my instructions as a whole. You must not single out or disregard any of the instructions on the law. You must consider only the evidence that I have admitted in this case. Evidence includes the testimony of witnesses and the exhibits admitted, but anything the lawyers say is not evidence and isn't binding on you. You should not assume from anything I have said that I have any opinion about any factual issue in this case, except for my instructions to you on the law. You should disregard anything I may have said during the trial in arriving at your own decision about the facts. Again, this will be left up to the jury, not the judge. So if anybody is out here talking about the judge is being influenced, this or that, the judge is letting you know very clearly that is not the case. Your own recollection and interpretation of the evidence is what matters. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances that tend to prove or disprove a fact. There's no legal difference in the weight you may give to either direct or circumstantial evidence. A deposition is a witness's sworn testimony that is taken before the trial. During a deposition, the witness is under oath and swears to tell the truth, and the lawyers for each party may ask questions. A court reporter is present and records the questions and answers. And we know that there was plenty of deposition footage played at the trial. So these are the instructions pertaining to that. The deposition of Caesar McDowell taken on July 25th, 2025 and November 13th, 2025. Sunstar Peterson taken on April 4th, 2025 and April 7th, 2025. Daystar Peterson, also known as Tory Lane, since they seem to be confused between Daystar and Tory, taken on April 9th, 2025 and November 14th, 2025. Livingston Allen taken on August 22nd, 2025 and October 22nd, 2025, and Antonio Tolfree taken on July 22nd, 2025, have been presented to you by video. Deposition testimony is entitled to the same consideration as live testimony, and you must judge it in the same way as if the witness was testifying in court. And I feel like this is actually an interesting piece as well, because we already know the contents of some of the depositions. We know the Caesar McDowell situation. He was very combative, very rude, rolled up a blunt during the deposition, walked out, excused himself, cursed people out. We know that the DJ that don't spin was very combative in his depositions, recorded one of the depositions and released it online. We also have Tory Lanez being rude in multiple depositions, excusing himself, walking out, being disrespectful to Megan's lawyers while trying to get through the line of questioning. So although in those circumstances you may not be able to say, oh, this person is lying with complete certainty, you can evaluate the nature of their behavior and just say, what is it that you have to hide? Why is this exchange so argumentative? Which at the end of the day, I don't think that bodes well for Milagro, because these people were supposed to be depositioned under their connections to her, which we already have evidence of those connections, but them lying or forgetting or being very disrespectful in that line of questioning, I don't know how the jury's going to evaluate that, but the judge says they have to. So we'll see how they run it down. Where a deposition was not presented to you by video, do not place any significance on the behavior or tone of voice of any person reading the questions or answers. Okay, so this is another good piece where they say, because you know the attorneys are gonna read excerpts and pieces out of the depositions to try to build their case or build their defense, and the jury is being instructed not to place significance on those readings, the tone of voice or the emphasis points or anything of that nature. Only focus on what you've heard in the recorded conversations directly from what they've played in court. All right, that's the next piece here. You have heard recorded conversations. This is proper evidence for you to consider. I'm going to allow you to have a transcript of the recording to help you identify speakers and guide you through the recording. But remember, it is the recording that is evidence, not the transcript. If you believe at any point that the transcript says something different from what you hear on the recording, disregard that portion of the transcript and rely instead on what you hear. You have also heard answers that defendant Ms. Cooper gave in response to written questions the other side submitted. The questions are called interrogatories and requests for admissions. Before the trial, defendant Ms. Cooper gave the answers in writing while under oath. And I don't know why the fuck I just said Ms. Cooper. Okay. Anyway, you must consider defendant Ms. Cooper's answers to as though Ms. Cooper gave the answers on the witness stand. So that's going to be very interesting as well, right? Because Milagro had to answer some questions that were submitted from Megan's lawyers prior to the trial. Those answers will also be held next to the answers that she gave on the stand. So if those answers are contradictory or somehow not in alignment, that could also call for question from the jury. When I say you must consider all the evidence, I do not mean that you must accept all the evidence as true or accurate. You should decide whether you believe what each witness had to say and how important that testimony was. In making that decision, you may believe or disbelieve any witness in whole or in part. The number of witnesses testifying concerning a particular point does not necessarily matter. To decide whether you believe any witness, I suggest that you ask yourself a few questions. Did the witness impress you as one who was telling the truth? Did the witness have any particular reason not to tell the truth? Did the witness have a personal interest in the outcome of the case? Did the witness seem to have a good memory? That's going to be an interesting question. Did the witness have the opportunity and ability to accurately observe the things he or she testified about? Did the witness appear to understand the questions clearly and answer them directly? Another interesting question based on what we know about these depositions and such. Did the witness testimony differ from other testimony or other evidence? I just was talking about that a few moments ago. You should also ask yourself whether there was evidence that a witness testified falsely about an important fact, and ask whether there was evidence that at some other time a witness said or did something or did not say or do something that was different from the testimony the witness gave during this trial. Looking for holes or contradictions. To decide whether you believe a witness, you may consider the fact that the witness has been convicted of a felony or a crime involving dishonesty or a false statement. But keep in mind that a simple mistake does not mean a witness was not telling the truth as he or she remembers it, okay? So there could be honest mistakes given in testimony, and there should be some room given for that, which the judge is also mentioning. People naturally tend to forget some things or remember them inaccurately. So if a witness misstated something, you must decide whether it was because of an innocent lapse in memory or an intentional deception. The significance of your decision may depend on whether the misstatement is about an important fact or about an unimportant detail. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness' opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. A party to a lawsuit, such as the defendant, has a legal duty to retain and preserve paper and electronic communications and other documents that concern the case. This includes, among other things, all electronically stored information in one's possession, custody, or control, such as emails, text messages, and other communications stored on applications on one's phone, computer, or in the cloud. Okay, so this is where they're about to get into Milagro's deletion, or the legal term spoliation of evidence. The day before plaintiff filed this lawsuit, her attorneys formally notified defendant that plaintiff was going to file the case and that she had these retention and preservation duties. Despite this written notice and these underlying legal duties, defendant deleted thousands of text messages and removed the WhatsApp app from her phone that potentially contained messages and chats. In reaching your verdict, you should assume and infer that defendant intended to deprive plaintiff of the evidence in the deleted messages and chats, that at least some of the deleted messages were related to the claims in this case and were about plaintiff, and that these deleted messages were unfavorable to defendant. Okay? So remember, they have to take that into consideration. In certain instances, it is the responsibility of plaintiff Megan Pete to prove every essential part of her claims by a preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. All right. So they also point out that Megan, and more importantly, her legal team, will have to prove every essential part of her claims. Okay. Now, what we do know is based on the accounts that we've been given about cross-examination and them taking the stand, Megan's legal team, they left more to be desired on the table in terms of proving the essential parts of her claims, right? Now, that doesn't mean that they didn't prove it. It's just that the way that John O'Sullivan was approaching the questions, the objections, and all of these different things, he could have handled it differently. That's a fair assessment that's been received from pretty much all parties that were present at this trial. A preponderance of the evidence simply means an amount of evidence that is enough to persuade you that Miss Pete's claim is more likely true than not true. If the proof fails to establish any essential part of a claim or contention by a preponderance of the evidence, you should find against Miss Pete. In other instances, which I will inform you of, it will be Miss Pete's responsibility to prove certain elements or claims by clear and convincing evidence. Clear and convincing evidence is a higher standard of proof than proof by a preponderance of the evidence. It means the evidence must persuade you that the claim is highly probable or reasonably certain. I will tell you when to apply this standard. Okay? Because more than one claim is involved, you should consider each claim separately. Plaintiff raises 3 claims in this action. First, for defamation per se. Second, for intentional infliction of emotional distress. Third, for promotion of an altered sexual depiction. Plaintiff can prevail in this case if she proves any of her claims by a preponderance of the evidence. I do believe the preponderance of the evidence will show at least 2 out of the 3. In my eyes, a 3 out of the 3. But I am not a jury member because clearly I wouldn't be online talking about this shit if I were. In deciding whether any fact has been proven by the burden of proof, you may consider the testimony of all the witnesses, regardless of who may have called them, and all of the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of Ms. Pete's claims by the applicable burden of proof, you should find for defendant Milagro Cooper on that claim. In this case, Ms. Cooper asserts the following affirmative defense: the substantial truth doctrine. Even if Ms. Pete proves her claims by a preponderance of the evidence or clear and convincing evidence, Ms. Cooper can prevail in this case if she proves an affirmative defense by a preponderance of the evidence. This is interesting. I caution you that Ms. Cooper does not have to disprove Ms. Pete's claims, but if Ms. Cooper raises an affirmative defense, the only way she can prevail on that specific defense is if she proves that defense by a preponderance of the evidence. The substantial truth doctrine. Let me see what that actually means real quick. So real quick, I just want to run this through. Substantial evidence is a term used in law to describe the level of proof needed to support a decision made by a lower court. Imagine you are watching a game and the referee makes a call. If there is enough clear evidence like video footage or witness statements to back up that call, we can say there is substantial evidence for it. In legal terms, this means that the evidence presented in a case is strong enough to convince a reasonable person that the decision made was correct. Interesting. When a case is appealed, the higher court looks at whether there was substantial evidence to support the findings of the lower court. This means they are not reevaluating the entire case, but checking if the original court had enough solid proof to make its decision. If the higher court finds that there was substantial evidence, it usually upholds the original decision. If not, it may reverse or change the ruling. Substantial evidence does not mean that the evidence has to be overwhelming or irrefutable. Instead, it refers to evidence that is adequate and reasonable enough to support the conclusions drawn by the lower court. Think of it like a puzzle. If most of the pieces fit together and create a clear picture, that's substantial evidence. It's about having enough pieces to see the whole image, even if a few pieces are missing. Okay? I just needed a little bit of layman's terms in that. That's all. I think we got it. On plaintiff's claim for defamation per se, there is a preliminary issue for you to decide. That issue is whether defendant Milagro Cooper is a media defendant. All right. This is a very large piece of this trial. The defense has been trying to give Milagro that media defendant role, which would substantially lower basically like the blow, so to speak, that she would face as a media defendant, right? This whole defamation thing, they say that it's hard to like hold a media defendant or a publication to defamation per se. Okay? So we'll continue. That issue is whether she is a media defendant. To qualify as a media defendant under Florida law, a party must be engaged in the dissemination of news and information to the public in order to initiate the uninhibited, robust, and wide open debate on public issues. Not every person or entity that publishes information is a media defendant. Okay? In deciding if defendant Cooper is a media defendant, you should consider whether the defendant won. All right? So we got some guidelines. During the time period in which the statements were made, provided disinterested and neutral commentary or editorialized on matters of public interest rather than advocated for a particular client or personal interest. That part is gonna, I don't know, you know, because she was definitely advocating for a particular client, in my opinion. During the time period in which the statements were made, regularly disseminated news or information to the public rather than making an isolated or one-time publication. That's where there could be a little bit of a defense for Milagro, because although she spoke heavily about Megan and negatively every time, she did have other topics of discussion in her shows. 3, during the time period in which the statements were made, impartially disseminated information rather than acting primarily to promote her own business, products, or services. We shall see about impartially disseminated information. Number 4, during the time period in which the statements were made, operated for the purpose of informing the public about matters of public concern through news reporting, analysis, or commentary. And 5, during the time period in which the statements were made, function in a similar manner to traditional news media, such as newspapers, magazines, television, radio, or their online equivalents, even if using newer platforms such as blogs or websites. Okay, so those are the 5 justifications for media defendant access. We shall see how they rule on that particular part. The fact that a defendant used the internet, maintained a website, or reached a large audience does not alone make that defendant a media defendant. Similarly, the fact that a defendant is not affiliated with a traditional newspaper or broadcast station does not automatically disqualify them from being a media defendant. And again, there's not a lot of context, or really not a lot of case law to kind of show for this. You know, this is a new law in Florida, and this jury is not really familiar with this whole media defendant thing. They left the court still asking the judge for direction, and they seemed a bit confused. Plaintiff Ms. Pete claims that defendant Ms. Cooper defamed her by publishing false statements about her on social media, which caused Ms. Pete harm. Ms. Pete claims Ms. Cooper defamed her by accusing Ms. Pete of perjury, a felony, by lying under oath in a criminal trial when she asserted that 1, Ms. Pete was a non-credible witness, 2, I could go down the list of all the different shit that was not true, and 3, asked, was Megan Thee Stallion caught trying to deceive the courts again? So those are 3 direct quotes from Milagro that the jury is going to have to evaluate. Was she implying or plainly stating that Megan committed perjury on the stand? And if they find that to be true, then this isn't going to hold up too well for Milagro. Okay? The issues you must decide for Ms. Pete's claim of defamation against Ms. Cooper are, first, whether Ms. Cooper published a statement about Ms. Pete. We know that to be true. Second, whether the statement was in some significant respect false. We know that to be true in plenty of instances. And third, whether Ms. Cooper made the statement with actual malice. That will have to be determined by the jury. I can't speak on actual malice. And fourth, whether Ms. Cooper's defamatory statement was a legal cause of loss, injury, or damage to Ms. Pete. Now, when I say I can't speak on actual malice, I mean legally I can't. But of course, my opinion is that she was operating with malice the entire time, especially with the vitriol that she had in her voice whenever she spoke about her. But that's just my personal opinion. The first issue you must decide is whether Ms. Cooper published the statements. A statement is published even when it is communicated to someone other than Ms. Pete or Ms. Cooper. In order to be communicated, a statement must be read, seen, or heard by a person other than Ms. Pete or Ms. Cooper, and that person must understand the statement's significance. I think that's pretty easy. We know for sure she published the statements. The next issue for you to decide is whether Ms. Cooper's statement concerning Ms. Pete was in some significant respect a false statement of fact, and if so, whether at the time the statement was made, Ms. Cooper made the statement with actual malice. A statement is in some significant respect false if its substance or gist conveys a materially different meaning than the truth would have conveyed. In making this determination, you should disregard any minor inaccuracies that do not affect the substance of the statement. A statement that is literally true in some significant respect, a false statement of fact if it is conveyed in such a way as to create a false impression. Actual malice is defined as knowledge that a statement is false or reckless disregard for whether the statement is false. That reckless disregard piece might get tough for Ms. Cooper. Ms. Pete must prove actual malice by clear and convincing evidence. Clear and convincing evidence is a higher standard of proof than proof by a greater weight of the evidence or preponderance of the evidence, all right? So this is going to have a higher standard, which means she's going to have to prove or have proved a little bit more to persuade the jury. It means the evidence must persuade you that the claim or defense is highly probably or reasonably certain. All right, y'all. It means the evidence must persuade you that the claim or defense is highly probably or reasonably certain. If Ms. Pete has not proven actual malice by clear and convincing evidence, then your verdict should be for Ms. Cooper. So that part could be pretty, I don't know. We're going to have to see. It could get tough for Megan in that regard, because I don't know if her legal team did such a great job of like doing clear and convincing. You know, the evidence that's submitted is pretty clear and convincing when you are aware of what's going on. I don't know how it comes across to a person that doesn't know anything about the situation. So we'll just have to see. Ms. Pete's defamation claim is what is known under Florida law as defamation per se. Florida law holds that certain statements are so harmful in nature that they are presumed defamatory as a matter of law. In a claim for defamation per se, the harmful nature of the statement is apparent from the words in the statement itself. Next, you must decide whether the statement was a legal cause of loss, injury, or damages to Ms. Pete. A statement is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage so that it can reasonably be said that but for the statement, the loss, injury, or damage would not have occurred. Okay? And I'm pretty sure had Milagro not done a lot of this shit, Megan wouldn't have endured some of the loss. In order to be regarded as a legal cause of loss, injury, or damage, a statement need not be the only cause. A statement may be a legal cause of loss, injury, or damage, even though it operates in combination with the act of another or some other if the statement contributes substantially to producing such loss, injury, or damage. If the appropriate burden of proof does not support the elements of Ms. Pete's defamation claim, then your verdict should be for Ms. Cooper. Actual malice must be proved by clear and convincing evidence. The remaining elements must be proven by preponderance of the evidence. However, if Ms. Pete has proved her claim, then you will consider the defenses raised by Ms. Cooper. You must now consider Ms. Cooper's defense. Ms. Cooper contends that the alleged defamatory statements were true. Yes, you are. Truth is an absolute defense to defamation. True statements, statements that are not readily capable of being proven false, and statements of pure opinion are protected from defamation actions by the First Amendment. To succeed on this defense, Ms. Cooper must prove by the preponderance of the evidence that the alleged defamatory statements were substantially true. A statement does not have to be perfectly accurate to avoid being defamatory if the gist or the sting of the statement is true. I don't know how she's going to be able to prove that her statements were true, though. At best, they were speculative that Megan could have been lying, but she had no actual proof to substantiate that she was privy to where the lies exist. At most, they were completely false. But we'll see how the jury rules on that. If the preponderance of the evidence supports this defense, your verdict must be for Ms. Cooper. If the preponderance of the evidence does not support this defense, your verdict must be for Ms. Pete. Ms. Pete claims that Ms. Cooper acted extremely and outrageously by coordinating with Daystar Peterson and others to distribute false statements about Ms. Pete and to promote and distribute an altered sexual depiction of Ms. Pete, which she did, which caused her severe emotional distress. This is known as a claim of intentional infliction of emotional distress. Defendant denies plaintiff's claim, and of course she denies that claim because she is trying to make people believe that she had no connection with Tory. It was just something that was on her heart that she needed to do. Okay. The issues for you to decide on Ms. Pete's claim of intentional infliction of emotional distress are: first, whether Ms. Cooper engaged in extreme and outrageous conduct; second, whether Ms. Cooper acted with the intent to cause severe emotional distress or with reckless disregard of the high probability of causing severe emotional distress. I would say so. There's even audio, which was not submitted to the courts for some reason, about her basically saying that Megan should go ahead and unalive herself if she can't handle criticism. Anyway, third, whether that extreme and outrageous conduct was a legal cause of severe emotional distress to Ms. Pete. Extreme and outrageous conduct is behavior which under the circumstances goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress so that it can reasonably be said, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. Continuous sequence, I would think 5 years would suffice, but that's just my opinion. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be its only cause. Extreme and outrageous conduct may also be a legal cause of severe emotional distress, even though it operates in combination with the act of another, some natural cause, or some other cause occurring after the extreme and outrageous conduct occurs, if such other cause was itself reasonable, foreseeable, and the extreme and outrageous conduct contributes substantially to producing such severe emotional distress, or the resulting severe emotional distress was a reasonably foreseeable consequence of the extreme and outrageous conduct, and the extreme and outrageous conduct contributes substantially to producing it. Now, my question is, how many of the jurors are going to be able to actually understand what Ms. Altanega is communicating in some of this? Because the language is very repetitious or repetitive, and I think that can be a little bit tricky. If the preponderance of the evidence does not support Ms. Pete's claim, your verdict should be for Ms. Cooper. However, if the greater weight of the evidence supports Ms. Pete's claim, then your verdict should be for Ms. Pete and against Ms. Cooper. Ms. Pete claims that defendant willfully and maliciously promoted a deepfake pornographic video of Ms. Pete on social media without Ms. Pete's consent. Ms. Pete alleges that Ms. Cooper knew or reasonably should have known that the visual depiction of plaintiff was in fact an altered sexual depiction, more commonly known as a deepfake, which Milagro went on record and on her stream to say it's got to be fake, that's got to be AI, which shows at bare minimum she thought it could have been fake. But then in court she says, I'm sorry, y'all, I thought it was real. But again, that's for the jury to evaluate. Okay? Issues for you to decide on Ms. Pete's claim of promotion of altered sexual depiction are: first, whether Ms. Cooper willfully and maliciously promoted an altered sexual depiction of an identifiable person, namely Ms. Pete. She admitted to doing it. Second, Ms. Cooper promoted the altered sexual depiction without the consent of Ms. Pete. Clearly, there was no consent. Third, at the time of promotion, Ms. Cooper knew or reasonably should have known that the visual depiction was altered. They have audio of that. I will now define some of the terms you must consider in deciding this claim. Altered sexual depiction means any visual depiction that, as a result of any type of digital, electronic, mechanical, or other modification, alteration, or adaptation, depicts a realistic version of an identifiable person. One with the nude body parts of another person as the nude body parts of the identifiable person. 2, with computer-generated nude body parts as the nude body parts of the identifiable person. Or 3, engaging in sexual conduct in which identifiable person did not engage. An identifiable person means the person in the image is recognizable as a real individual, for instance, by their face, likeness, or other distinctive features such as a unique birthmark. Willfully means that Miss Cooper acted knowingly, intentionally, and purposely. Y'all go check my likes. Maliciously means Miss Cooper acted with wrongful intent, for example, intentionally doing a harmful act without any lawful justification or excuse. To promote means to distribute or disseminate material, including issuing, selling, giving, lending, delivering, transmitting, publishing, posting, circulating, exhibiting, or sharing it, or agreeing to do any of these actions. I don't think there's any way to refute it. She shared it in her likes, but not only did she share it in her likes, she promoted it on her live stream, and she also said anybody who's willing to pay her the $20, she will send them the unredacted version. Without consent means Miss Pete did not agree to or authorize the altered depiction being shared in any manner. The presence of a disclaimer within an altered sexual depiction which notifies the viewer that the person or persons depicted did not consent to or participate in the creation or promotion of the material, or that the person or persons depicted did not actually perform the actions portrayed, is not a defense and does not relieve a person of liability under the law. If you find that all of the above elements are proven by preponderance of the evidence, then you should find for the plaintiff on this claim. However, if the plaintiff fails to prove any one of these elements, you must return a verdict for the defendant on this claim. If your verdict is for Ms. Cooper on defamation, intentional infliction of emotional distress, and promotion of an altered sexual depiction, you will not consider the matter of damages. But if the preponderance of the evidence supports any of Ms. Pete's claims for defamation, intentional infliction of emotional distress, or promotion of an altered sexual depiction, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows will fairly and adequately compensate Ms. Pete for her loss or damage, including any damages that she is reasonably certain to incur or experience in the future. You shall consider the following elements of damage. A. Nominal damages. If you find for Ms. Pete, but find that no damage has been proved for her intentional infliction of emotional distress claim, you may award nominal damages. Nominal damages are damages of an inconsequential amount which are awarded to vindicate a right where a wrong is established but no damage is proved. By nominal, I mean a dollar amount of damages such as $1 that you, in your discretion, determine. B. Compensatory damages. If you find for Ms. Pete and against Ms. Cooper on any of Ms. Pete's claims, defamation, intentional infliction of emotional distress, or promotion of an altered sexual depiction, you may award compensatory damages. Compensatory damages are damages amounts awarded for 1. Medical expenses for Ms. Pete. We already know that she spent hundreds of thousands of dollars to go to a 30-day retreat for mental health. These compensatory damages are for the reasonable value or expense of medical care and treatment necessarily or reasonably obtained by Ms. Pete in the past or to be obtained in the future. 2, lost earnings, lost working time, lost earning capacity, not to mention she paid money for a therapist. These compensatory damages are for any earnings, working time lost in the past, and any loss of ability to earn money in the future, any loss of ability to earn money sustained in the past, and any such loss in the future, injury to reputation or health or shame, humiliation, mental anguish, hurt feelings. Ugh. These compensatory damages are for any injury to reputation or health and any shame, humiliation, mental anguish, and hurt feelings experienced in the past or to be experienced in the future. There is no exact standard for fixing the compensation to be awarded on account of such elements of damage. Any award should be fair and just in the light of the evidence. C. Punitive damages. There's an additional claim in this case that you must decide. If you find for Ms. Pete and against Ms. Cooper on her claims for defamation or intentional infliction of emotional distress, you must decide whether, in addition to compensatory damages, punitive damages are warranted as a punishment to Ms. Cooper and as a deterrent to others. So this would set the example. Ms. Peet claims that punitive damages should be awarded against Ms. Cooper for her conduct in coordinating with Mr. Daystar Peterson and his affiliates to distribute, promote, and disseminate false and disproved statements and theories about Ms. Peet, and to intentionally or recklessly promote and distribute an altered sexual depiction of Ms. Peet. Punitive damages are warranted against Ms. Cooper if you find by clear and convincing evidence that Ms. Cooper was guilty of intentional conduct or gross negligence, which was a substantial cause of loss or damage to Ms. Peet. Under those circumstances, you may, in your discretion, award punitive damages against Ms. Cooper. If clear and convincing evidence does not show such conduct by Ms. Cooper, punitive damages are not warranted against Ms. Cooper. Wouldn't she be Mrs. Cooper because she's married? Intentional misconduct means that Ms. Cooper had actual knowledge of the wrongfulness of the conduct and that there was a high probability that injury or damage to Ms. Peet, and despite that knowledge, she intentionally pursued that course of conduct resulting in injury or damage. Gross negligence means that Ms. Cooper's conduct was so reckless or wanting in care that it constitute a conscious disregard or difference to the life, safety, or rights of persons exposed to such conduct. That deep fake gonna hurt you. If your verdict is for Ms. Cooper on Ms. Peet's claim of promotion of an altered sexual depiction, you will not consider the matter of damages, but if the preponderance of the evidence supports Ms. Peet's claim for promotion of an altered sexual depiction, then the law allows Ms. Peet to recover monetary damages in an amount of $10,000 or actual damages incurred, whichever is greater, for each instance that occurred, and reasonable attorney's fees and costs. Of course, the fact that I've given you instructions concerning the issue of Ms. Peet's damages as to any of her claims should not be interpreted in any way as an indication that I believe that Ms. Peet should or should not prevail in this case. Your verdict must be unanimous. That's also going to be the tough part, is them coming to a unanimous resolution. In other words, you must all agree. Your deliberations are secret, and you will never have to explain your verdict to anyone. Each of you must decide the case for yourself, but only after fully considering the evidence with the other jurors. So you must discuss the case with one another and try to reach an agreement. While you are discussing the case, don't hesitate to re-examine your own opinion and change your mind if you become convinced that you were wrong, but do not give up your honest beliefs just because others think differently or because you simply want to get the case over with. Remember that in a very real way, you are judges of the facts. Your only interest is to seek the truth from the evidence in this case. When you get to the jury room, choose one of your members to act as foreperson. The foreperson will direct your deliberations and speak for you in court. A verdict form has been prepared for your convenience. Take the verdict form with you to the jury room. When you all have agreed on the verdict, your foreperson must fill in the form, sign it, and date it. Then you will return it to the courtroom. If you wish to communicate with me at any time, please write down your message or question and give it to the court security officer. The court security officer will bring it to me, and I will respond as promptly as possible, either in writing or by talking to you in the courtroom. Please understand that I may have to talk to the lawyers and the parties before I respond to your question or message, so you should be patient as you await my response, but I caution you not to tell me how many jurors have voted one way or the other at that time. That type of information should remain in the jury room and not be shared with anyone, including me, in your note or question. So those are the directions from the judge. And again, I think some of the toughest parts of this will be the actual malice piece and the fact that they have to come to a unanimous decision when we don't know anything about these people, really. We don't know their mental state. We don't know their education. We don't know anything about these folks, right? And clearly, they're not supposed to be privy to any of the material facts of this situation prior to them being selected as jury. So we honestly can't really predict how this is going to go. This is in Florida. Nothing against Florida, but y'all got some unique people out there. So that also is going to be a bit of a wild card. We don't know what type of beliefs these people hold. So it's not my job to persuade anybody or change anybody's mind. I have my opinion of this situation. You as the viewer have your opinion of the situation, but none of our opinions will impact this in any significant way or any way, period. So please keep that in mind. Even when you come across others who have opposite opinions, please have discretion on what you allow yourself to be triggered by, because ultimately the decision will happen on Monday, and whatever decision they come to will be for whatever they choose, and we'll have no influence on it. All right? Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I will catch y'all on the next one. All right? Much love and respect, y'all. Peace. Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'm never politicking, the drama be piling on. Father and great son acknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts, every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy calls, consulting for the stakes I built. I